Hello and welcome back to the fourth module of this course on labor and decent work in supply chains. So far in this module, we have learnt about some methods that workers can use to access their rights and improve their conditions of work. One set of such methods were remedies under Indian law. Another set of methods relied on non-judicial remedies established by intergovernmental organizations and sources of international finance. A third category of methods involves the practice of collective bargaining. We have previously in this course noted the crucial role that organized labor has played in accessing decent work. We learnt the provisions of the Indian Constitution and the various international conventions that recognize the importance of workers freely associating with one another to pursue common objectives. The recognition of this principle in these documents, however, has not automatically meant that workers everywhere are free to group together and negotiate better conditions of work.
Presently, freedom of association is one of the core labor standards, and therefore it is a basic human rights. But still, companies often go into countries where governments, industry, where they oppress organization of laborers. Many buyers of garments and other products, they know, for example, that if they source from countries like Bangladesh or India, that or China, of course, that unions are there under a lot of pressure. China never allowed free unions. But they still source there, and they reward the oppression of against unions by that way. Workers should have the right to organize. They should have the right to fight for wages, which are a living wage, and therefore companies should not weaken the position of unions by leaving countries where unions get stronger and wages get higher. But the opposite is often happening. There are exceptions, like a couple of years ago when there were unions striking in Cambodia and the government reacted with police violence. There were some companies who tried to convince the government to pay higher wages and to accept the unions. But the government said, well, if we accept significantly higher wages and the living wage, it might happen that some of the companies will still procure in the countries. But these people who now demanding this from us, they are not the majority of the buying companies here. So there is even here, even if it is government oppression often of unions, there is a responsibility of companies. Their sourcing strategy usually goes only for the cheapest place, and if you go to the cheapest place, you have low wages and often union oppression.
As we have learnt previously, global buyers tend to seek out suppliers in parts of the world where there is insufficient freedom to associate. In many parts of the world, national governments are complicit in stifling the freedom of workers to associate with each other and bargain collectively. We had previously learnt about the struggles that led to the legal recognition of trade unions and how laws for the registration of trade unions protected trade unions and their leaders from legal liability for anything done in the context of a dispute between employers and employees. Such legal protection offered by registration is often not sufficient for trade unions to properly litigate the demands of workers.
The Central Labour Law, the Trade Unions Act 1926, merely provides for registration, legal registration of trade unions, and registration is voluntary. So any trade union, any workers organization may register or may not register under the Trade Unions Act. And the Trade Unions Act does not talk about mandatory recognition of trade unions by the employers for collective bargaining purposes, which we call technically as the bargaining agent or the negotiating agent. The Central Trade Unions Act is defective to a large extent. Since labor is on the concurrent list, several state governments, it started from with the Bombay province earlier, and it was the first province to legislate for providing for trade union recognition under the Bombay Industrial Relations Act 1946. And then, of course, it was copied by Madhya Pradesh as Madhya Pradesh Industrial Relations Act 1960. And then again, Maharashtra introduced Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971. And of course, a few states in the later, like the West Bengal, and in the 1999, in exactly 1999, and Kerala later in 2005 or thereabouts, provided for compulsory recognition of trade unions. See, the point is that unless the law mandates the employers to recognize trade unions for collective bargaining purposes, legally the position is that it is a discretion of the employers to recognize the trade union or not. So there are good organizations who recognize voluntarily even without the legal mandatory clause, like Tata Steel and Mahindra and others. But not many organizations, including the multinational corporations, for example, some multinational corporations in the FMCG, which are very well-known brands. Which I will not be naming them for obvious reasons, but well-known multinational brands in the FMCG sector for a long time did not even allow the trade unions for recognition. Did not recognize the trade union and was not ready to invite the trade unions to the negotiating table.
Here we need to once again consider the legitimacy of strikes as a tool of collective bargaining. Without the freedom to strike, the freedom of association can be meaningless for workers who want to demand better conditions of work.
And secondly, logically, the right to form associations and trade unions, for it to be really sustainable, because what do the trade unions do? The trade unions will have to typically engage in collective bargaining with the employers. They need to be recognized. They need to be recognized as bargaining, negotiating agents, and once it is done, they need to negotiate with the employers, and collective bargaining, free collective bargaining, as we teach, involves the possible employment of threats and sanctions to make the negotiations a little more effective. For example, there is an impasse in the negotiation process. That is, the two parties to the on the negotiating table do not come to a conclusion. There is an impasse. Let us say the workers initially demanded that some 40% wage rise, and employers started with about 10% wage rise. And after negotiations, the final offer of employers is about, let us say, 15 to 18%. Let us say 18%, and the final acceptance offer by trade unions is about 25%. So there is an impasse. Neither the employer nor the trade unions want to be any more flexible. Then the negotiation gets stalled. Then what does one do? Then, according to the free collective bargaining theory, which of course originated from Western countries, primarily the North American context, and later in the British context, the employers and the trade unions should have some instruments or sanctions to threaten the employers. Look, if you don't give us 25% of wages, we are threatening that we will go on strike, which means withdrawal of labor supply from the firm. And typically, the counter weapon to strike is lockout. The employers must be able to tell the negotiating trade unions, look, we have done our max, and we cannot offer you any 0.1% higher than 18%. If you don't accept we will lock you out of the factory, which simply means a temporary work stoppage. If it is initiated by workers, trade unions, it is called strike. If the same is initiated by the employees, it is called lockout. Now the threat, the credibility of the threat is very important. In other words, the trade unions must, supposing the employers say, look, we have done the max, we are willing to take a strike. If you want to go on a strike, you can very well go on a strike. But then the trade unions must have considerable majority of workers who are willing to go on strike and who are the members of the trade unions. So the threat shall become a credible threat in only those cases where the trade unions can carry out the threats in a credible and effective manner.
We had learnt previously that under India's industrial disputes law, some types of labour action are classified as illegal strikes. By compulsorily requiring disputes to be resolved using specific resolution mechanisms, Indian law limited the tactics that trade unions and workers could adopt in their negotiations with employers. We can now consider from a constitutional perspective whether laws that limit the freedom to strike violate the fundamental freedom of association. To put it simply, the question before Indian courts was whether legal limits that are placed on the freedom of strike violated India's constitution.
But the Supreme Court in India, over several judgments, took the view, after careful consideration of Article 19(1)(c) and the entire edifice of Constitution, even a reasonable interpretation of Article 19(1)(c) does not allow us, the judiciary, to grant that the right to strike would be elevated to the fundamental right to strike. At best, it could be, of course, Supreme Court added, to be sure, the Supreme Court added that we do recognize that right to strike and right to lockout are important weapons in the armory of the workers and trade unions as negotiating parties, and they must have them. But all we can say is that it can be a legally regulated strike. In other words, the strike and lockout will be regulated by certain labor legislation, and we will leave it to the labor legislation. So the right to strike is not a fundamental right in India, say like in France or like in China till 1981-82, or in Italy or some other countries. It is a legal regulated right to strike as well as lockout, and the Industrial Disputes Act regulates the entire process of conducting a strike and lockout by imposing certain procedural formalities.
Indian courts have denied that the freedom to strike had the same status as the freedom to associate. The latter is a fundamental right that enjoyed constitutional protection. The former is subject to legal regulation. This is often meant that workers would find that their freedom to associate was not truly meaningful.
In Tamil Nadu, it is very difficult to right to organize workers by the trade union. It is very difficult, sir, in Tamil Nadu, because you know that Tamil Nadu, there's textile suppliers, they got a special order from the court. They should not enter into the factory, even the gate meeting. They should be outside from the 500 meters from the gate. They can organize, but not inside the factory or gate meeting. So therefore, it is very difficult to organize a negotiation with their demands with their suppliers addressing their grievances with the suppliers is very difficult. Particularly this textile association, they went to Tamil Nadu High Court. They got special order, sir. Special order. This is, sir, 8 years back, sir. I don't know exactly that year. This order, sir, because these suppliers they feel the text, particularly trade union, the organizing workers, they're disturbing their business, even they're disturbing their target production. Always they're conducting strike and dharna rally, protest. So it is affecting their entire their business. That is their feel. Therefore, they got order from High Court, sir.
Another limit placed on the freedom to strike has emerged from the Essential Services Law.
The Constitution provides emergency powers to the state governments as well as the central government to pass essential services maintenance ordinance if the parliament is not in session, to be converted into a ordinance and then converted into an act, which will be in vogue for 6 months from the date of legislation, and then of course it can have extensions by a couple of times. So many of the state governments, the central government started using this ESMA, Essential Service Maintenance Act. It used this ESMA facility, that too by Jawaharlal Nehru, when the central government employees went on strike for demanding pay rise and DNS allowance in 1960-61. And later again in 68 and thereafter, the state governments have started using this ESMA, invocation of ESMA rather liberally and generously, and the pain point in this particular ESMA legislation is that it is defined in essential services is given a blanket definition, so that the government, the state government usually can include any industry under the rubric of essential services. For example, I can tell you, Uttar Pradesh in the 1980s invoked the Essential Service Maintenance Ordinance when the higher secondary teachers teaching in the higher secondary institutions went on a strike. Now the ILO has formed a lot of principles with regard to the right to strike, and they have the Committee on Freedom of Association, which is a committee which is their supervisory body formed by the ILO to supervise and make suitable interventions on the violation of by any country. Convention 87, which deals with freedom of association, and Convention 98, which deals with freedom of collective bargaining. And the principle is very clear. The essential industry definition means stoppage of work which should pose an immediate threat to life and life and existence of people. And it has given certain examples. Of course, some strikes, if they prolong a particular period, may assume the character of an essential service. But we do not have an essential service defined in the Industrial Disputes Act. However, I must also add here the Industrial Disputes Act has a provision called public utilities, and the central government, the ID Act has empowered the central government and the appropriate government, that is the central government for the central sphere and the state government for the state sphere, to declare certain industries as public utilities, which means that under the Industrial Dispute Act, this public utility, the employees in the public utilities cannot go on strike without giving strike notice, and they cannot continue to be in strike when the conciliation process is in process, and even after the conclusion of conciliation proceedings, or when the industrial disputes are being heard by the compulsory adjudication authorities like Labour Court and Industrial Tribunal, and 3 months or 6 months thereafter. So the typical thing that the government does is that it declares IT industries, it declares cement industry, it declares any industry which the employees group wants the protection, goes to the government and says, look, why don't you issue a notification to declare our industry as a public utility. For example, in Karnataka, the NASCAM, the IT enabled industry and knowledge industry body has consistently asked the state government of Karnataka to declare IT and IT enabled industries and knowledge based industries to be public utilities, so striking becomes very difficult. Of course, there has been a debate in India whether the IT employees in the IT sector and ITES, IT enabled sector, and the knowledge sector, do they have the right to strike, and labor laws are applicable to them. So recently after the TCS, around the time of the TCS case, where they proposed layoffs, which means retrenchments of thousands of employees. There was a union formed called the National Democratic Labour Front (NDLF) in Tamil Nadu, and of course later we have some other associations that have come, which asked the Tamil Nadu government, which filed a petition in the High Court, and the High Court directed the Tamil Nadu government Labour Department to state clearly whether the ID Act is applicable to the employees in the IT sector. So initially the Tamil Nadu government did not respond. After a couple of warnings by the Madras High Court, the secretary to the Labour Department gave an unequivocal declaration that ID Act applies to the IT and IT enabled services to the extent that the worker definition is applicable to them.
Previously, when we learnt about the agricultural production of cotton and sugarcane, we noted how agricultural work was largely seasonal and informal. Agricultural workers were not organized into unions. Several features of agricultural production prevent workers from coming together to demand better conditions of work.
Okay, so I think from the previous context, we understand that the agricultural workforce engagement is characterized by the relatively higher power of the land owning farmers vis-a-vis very large number of agricultural workers who don't have any kind of asset or access to any kind of formal support system. And in that case, the bargaining power is very heavily tilted in favor of the farmers. And the farmers can come together, the small number of large farmers can come together and actually take a collective call on what kind of wage rates, what kind of working conditions we would employ in our community. And then the workforce, which is dispersed and disparate, will not be able to negotiate effectively with them. In such a scenario, the only strategy that works for the agricultural workers is to come together as a collective. And there have been some experiments in the agricultural workforce coming together as a collective and doing the negotiation at a collective level with the farmers or their employers to negotiate better wages, to negotiate sometimes working conditions, and to a certain extent they have been successful in, especially in some of the southern states like in Kerala and Tamil Nadu, and also to be able to appeal to the state system in terms of adherence to some of the stated public policies related to minimum wage and social security and things like that, right? So the collective mechanism has the potential, but when we then think about agricultural trade unions, now there have been fairly large trade unions combining farmers and workers, and for example the Kisan Mazdoor Sangh and things like that. Now often what that does is that kind of a trade union actually equates the farmers and the workers at the same footing, in that sense that it's a trade union of small farmers at members to protect the interest of the farmers and workers. When this trade union is talking about workers, they're essentially talking about non-farm workers employed in the industrial space. So there are experiments of trade unions that bring farmers and workers together, but in that context, farmers interest and the non-farm industrial workers interest that is being represented by the trade unions. The other big constraint in that sense the agricultural workforce face is that, unlike in an industrial setting where you are reasonably or most of the time the employer is reasonably resourceful in order to in order to pay, or in order to adhere to the various systems like minimum wage or social security and things like that. in an agricultural setting, often a very large number of farmers in India themselves are under tremendous amount of financial stress. The agricultural sector hasn't been going through, generating profits or surplus for the farmers themselves. So when you are employed uh, by an employer who himself is not able to make a reasonable surplus out of the enterprise, which is what the Indian agricultural sector is going through since almost last 2 decades, it puts the workers in that much more of a vulnerable situation, because their employer itself is not generating adequate surplus to be able to afford social security mechanism or increased wage rates, etc. And often, in that context, the workforce kind of believes that they need to be more accommodative to the interest of their employers. The fact that they understand that the farmer himself is not making a large amount of surplus out of the operation means that they need to compromise in their own interest, in terms of whether it comes to the interest related to wages or working conditions or social security mechanism, and they cannot make these demands of their employers. So in that sense, the solution to this problem is not simple, and in the sense that we can pass policy regulation and then ask the employers, in this sense, the farmers in India, to start absorbing this cost. The state needs to really, while formulating policy, need to also then think about what kind of enabling mechanism can be built in, so that the additional cost of compliance for these policies, be it when we are saying minimum wage rate, when the state is declining minimum wage rate, it also needs to then do a cost benefit analysis for the farmers who need to employ these agricultural workers, and see whether the farmer is making enough surplus from a crop like paddy, wheat, cotton, sugarcane, to be able to afford these additional to afford to pay these minimum wage rates. If we are expecting the farmers, or we are expecting some kind of a social security system or health insurance or accident insurance system, whether then the employer, the farmer, is able to pay for the premiums of this. In a situation where the agricultural or the farmers themselves are stressed and are unable to take on the cost of this, the only mechanism feasible would be for the state to step in, as a support system for taking the tab of many of these the cost of this kind of support mechanism, be it a social security system, be it a insurance, health or accident insurance system. The premium of this then need to be taken care by the state rather than the employer. Unfortunately, a number of these are then stuck in because of the overall viability or the economic profitability of the agricultural system itself. And in that sense, that's just a stark reminder of how exploitative our food or agricultural system have been, that even a farmer with a reasonable amount of capital in terms of land holding, who is engaging in commercial cropping, be it cotton or be it cane sugar, which are all commercial so-called cash crops, are really then not able to generate adequate surplus from this venture to be able to provide for reasonable expenses for their own production system, in order to take the right cost of the workforce. And hence, the correction mechanism has to be thought throughout the supply chain, right from correcting market prices, which need to account for the total cost of production for these goods.
Many of the features of agricultural production that make it difficult for workers to come together into unions and demand better conditions of work are also present in other parts of the labor market.
Oh, this is completely mess. You organize somebody. For first example, even in the COVID-19 crisis at this moment, you can see that there's almost 200 million workforce are kind of stateless. They don't have any ID card. They don't have any ration card. So you know that there's a huge migratory population. So you say, like, okay, let me give you example. If this year, if I'm organizing a bunch of construction workers, and mostly these people are the seasonal migrants, you, let's say that you build the union, and you build the union and you nurture the union, you talk about the rights, etc. But next year they might not come to Maharashtra, where I'm working right now. They might go to Punjab next year. Next year they might go to Delhi. So these migratory populations do not have very clear geographical locations where they will go every year and work on that. So that's a one question. Second question is also that these are the floating population. Today, if they have a work, they can work as a construction workers. If they don't have any work, they may become the street vendors. If tomorrow there will be some eviction happen, then street vendors become again the daily wagers. So the informal workers is so vulnerable. It's so fragile. It's very different to organize them. Today they can be something, tomorrow they can be something else. So you know what I'm talking about. That it's a very kind of very fractured and very fragile kind of framework where it's so difficult to organize. And same complaints come from our organizer, including myself. I organize in so many sectors. So it's so difficult that you cannot hold the workers. For example, if you are in an organized sector, you can hold the strike. But under the strike, they may get the wages and etc. because they are under part of the informal employment. But you think about if the daily wages, if they sit on the strike for 10 days, their daily wages, they earn every day 300, 400 rupees, and they eat. And if they go on the strike for next 10 days as part of the struggle, the entire family won't have even enough food to eat. So forget about the struggle. So it's completely different and very challenging. I hope you're understanding the case I'm trying to build it. Yeah.
In the context of agricultural workforce, especially migrant agricultural workforce, their ability to connect with a peer group to create a collective, workers collective, or a workers union fails because every year they're essentially getting employed for a temporary basis and with new employers, often in new clusters altogether, and that is moderated through a labor contractor, and hence their ability to connect with peer group, have a consistent peer group which can come together as a union, is then compromised, and that kind of a labor union it becomes infeasible to that extent. Uh, in that context, then the only successful model can come about when you have a civil society organization which is then coming to their rescue, is actually facilitating, is often replacing this middleman of the labor contractor, is actually facilitating the direct connection between the production clusters where this is happening, and is organizing the migrant labor through a registration process, and only in that cases, and those cases are very few and far between, where we have seen some level of or some degree of unionization coming together, or collectivization coming together, through which better collective bargaining is then feasible.
So far, we have learnt some of the problems that limit the ability of workers to organize effectively. Some of them emerge from the law itself. There are legal limits placed on the ability of workers to organize. In agricultural production, many of the difficulties arise from the nature of the market itself. The bargaining power is heavily tilted in favor of large farmers. Work is often seasonal and the workers are often migrants. Faced with such difficulties, we must learn from the experiences of workers who organize to negotiate with employers and with the state to raise the minimum standard established by labor laws.
In recent years, yes, there are one big success. In Delhi, we formed the minimum wage advisory board after 21 years, and we negotiated, we organized series of struggle, and we convinced the state government to revise the minimum wage structure. And I don't want to basically go in very technical terms, but there is a whole determining framework laid down by the Supreme Court. And Supreme Court talked about the whole concept of the need-based minimum wages, which largely can be translated as a living wage. And we managed to brought in those concepts as part of the policy fold, and through the struggle we managed to bargain and negotiate with the government, and we increase the minimum wages to the living wage standard. It was the first time then when the Delhi government managed to implement the landmark Supreme Court order in the case called Rabta Cost Bread Guidelines to reach on the living wage standard. That is kind of one of the big success for all of us, and also creating a bar, also creating a standard, which basically created a ripple effect across the country. And therefore, after that, there's an increase in the garment workers wage in Karnataka. There's an increase in the minimum wages in the scheduled category in the Maharashtra. So that Delhi example actually sort of created a ripple effect and also created a new debate of the whole idea and concept of living wages. I think in the recent years, we managed to organize domestic workers very successfully. And we also managed to organize bricklaying workers successfully. This is part of my own work in the last 10 years. And it was a continuous effort, even though workers are migrating from here and there. But wherever they're migrating, they are going in the different states, different locations. And they are always kind of opening to the union process, or finding the local union process where they go and joined in and talked about the wage right, talked about the collective bargaining and all. So organizing workers in a way created a kind of a situation where workers realize it is also very important to create or provide a political education to the workers. They should understand that how they can go beyond the caste, class, gender, this whole capitalist framework by which they function, and they can actually understand the whole power of the union. They can actually understand the whole power of the collective bargaining. So even though if they're migrated, they may not be part of my whole local union ecosystem, but wherever they migrated, they actually eventually connected with their local union system. So I think that is a big success where we managed to create a kind of enable a situation where workers felt and always being demanding the need of the union power.
This brings us to the end of this video on collective bargaining for decent work in global supply chains. Workers find it difficult to organize, not only because of the nature of work involved in many of these supply chains, but also because of the constraints placed on the freedom of association in India. In spite of these difficulties, labor organizers have developed some strategies for organizing and bargaining collectively. In this module, on the various methods that workers can use to access decent work in supply chains, we learnt about some of the remedies available under Indian law, some remedies that can be accessed through intergovernmental organizations and sources of international finance, and finally about collective bargaining in the context of supply chains. With this, you now have a good understanding of labor law, international standards, and about collective bargaining, and how all of this can be applied in the context of supply chains. Thank you for watching, and thank you for learning.